Hello, and welcome to the IMS Insights Podcast. I'm your host, Adam Bloomberg. Today, we're speaking with Professor Ian Cullimore, a lifelong inventor and patent expert with extensive experience in complex litigation involving computer technology. Joining him is IMS trial consulting lead Dan Martin, who has spent more than 20 years helping litigators develop winning visual strategies for high-stakes disputes. Our guests will explain how to simplify the most sophisticated intellectual property into compelling presentations that judges, juries, and tribunals can comprehend. They'll also discuss strategies for expert witness reports, presentation requirements for Markman hearings, and the collaborative process between experts and graphic designers. If you're listening only and would like to watch the video version, please visit our YouTube channel. Starting with you, Ian, welcome aboard. I know you are currently in London. It's about, I think you said it's around 5 p.m. there. So thank you for joining us here this evening. You've worked on a number of patent disputes in the UK and here in the States in Silicon Valley. So I'd like to start with kind of your strategies for testifying in, say, a trial or an international arbitration where you're having to distill complicated concepts. You know, I've often heard the role of an expert is like a grade school science teacher. So with that in mind, let's start with, you know, what sort of tips do you have for testifying?
Yeah, sure. First off, it's very good to be here, so thanks for that. Very good. So I think the big thing for me is plenty of time prepping with counsel and understanding their strategies, where they're trying to get with this case. And also they'll normally have an understanding of what, if it's a trial, say, what sort of level the judge is at, and the jury too. They might well know the jury members and will have an idea of what sort of, if they're tech savvy or not. So you can start to judge what sort of level you've got to start to explain these things to people with. One thing I find is to, don't be condescending to people. Don't talk down to them, but don't talk up. Don't try and make out that you're super smart and all that sort of thing and try and belittle them. Just try and get the level right so that you can explain these concepts to them. You may be allowed to do diagrams and whiteboarding. Sometimes you can, sometimes you can't. So oftentimes diagrams are very useful to explain some of these concepts. Often use analogies. Again, if you've got people who you think aren't that tech savvy, it's difficult to explain complex issues like how the internet works or how electronics work or how software is designed and so forth. So using analogies of the flow of water is like electricity, for instance, and how simple sort of electronic circuits are put together. So just try and understand your audience and judge that and talk to the right sort of level if you can.
Well, I have an idea that you're a pretty good teacher. You've got your whiteboard there in the background. So you've been hired as an expert in patent cases regarding specifically mobile operating systems. How do you start to think about simplifying, say, the inner workings of program language in say your initial meeting with counsel?
Again, what I was saying before, try to understand their level. With counsel, it's a bit different. What I found in my arena of work is that oftentimes they'll have done a double E degree first, and then got into law and got a law degree and specialized in intellectual property. So oftentimes you're talking to your counsel and they are pretty tech savvy. On the other hand, you know that you'll be writing an expert report and you need to get the right sort of level for that. If it's going to go to trial, again, you'll be explaining to a judge and a jury. So you have to lower things down a bit. And again, just use, simple analogies of how these things work. Fortunately, as time has gone on, I mean, it was a more difficult task when I first started as an expert witness because, programming languages were complex. It was all low level, assembler language, difficult languages. As time's gone on, it's got easier actually, and that's been beneficial because programming languages are easier now for people, anybody just about to start to bang out an Android or iPhone app. So that actually makes the task easier to explain to people how to do it.
Consider myself tech savvy, but when it comes to programming mobile applications, I have to be honest, my eyes glaze over a little bit. So I want to try something out. Will you humor me for a second here? How about you tell us, how would you explain the internet to, say, an 8th grade science class, maybe like a jury, And then conversely, how would you explain the internet to, say, a graduate level class, like something like a tribunal, where they already have a general understanding of kind of the technology at play?
Yeah, sure. And in fact, it's an interesting question. I had a case like this where I had to do both things at the same time, basically. That I had a judge and some other panel members who were not very tech savvy, but also had counsel on the opposing side who were very tech savvy. And so I had to try and do both at the same time. So explaining things simply to the half of the audience, trying to explain that there are parts they didn't need to worry about. When you type in a domain name www. Apple.com or something like that, what's really going on? Well, there's some deep complexities in the background of it, but really you don't have to worry too much about that. Just explain that there's some communication going on over the wires or wireless, and these back-end servers understand, and they just know you want to have some data displayed on your phone for this particular website, or buy something off Amazon or whatever it is. On the other hand, if you've got counsel who are tech savvy, which they were in this case, they really wanted to drill deep into the technology of this and almost try to make out that, I didn't know quite what I was talking about, but I had to show in this case, I didn't want to bamboozle the judge, but I had to show in this case that I really did know the deep inner workings of how the internet works, and TCP/IP and packets and, secure layers and so forth. So you just got to judge it right, I think, for the target audience.
So Dan, it's your turn. As a trial consultant, you might also be able to approach your work differently in these kind of two scenarios that we're talking about. So given what Ian's talking about here, what sort of visuals come to mind based on that? I mean, how would you approach visuals for these two scenarios?
Right. Thanks, Adam. It's good to be with you guys today. Yeah, the internet, I think, is a really great example of sort of an everyday use that we kind of take for granted, and that probably very few of us truly kind of understand the inner workings of. So for the lay jury, I would probably recommend leaning on, simple graphics that start with the basics. It's both worldwide and it's both wide and narrow. It's worldwide, it's personal. And so, it's a singular experience dependent on satellite connectivity, presumably a top endless array of networks. So these are things that can be illustrated quickly with symbols and icons, and these things we're used to associating with technology. So to the extent we can minimize the words on the screen for the jury that would compete with the verbal narrative of an expert like Ian or counsel, I think better off we'll be with the jury. So it would be, a different approach for a sophisticated arbitration panel, for instance, like the one that Ian described. You can get away with a lot more technical descriptions, I think, and less reliance on everyday analogies like the water flowing type thing. The panel would likely find more benefit in more descriptive, detailed text, maybe right on the slide, on the graphic, than a jury would. A little more appetite for that. So essentially, the panel would have more capacity for understanding complexity, and the expert can use that, in my experience, to their advantage when they're doing their visual presentations.
So Ian, during one of our prep calls, you mentioned a case years ago where you were called to testify about mobile technology, and it was a criminal dispute in the UK, right? Yeah, that's what it was. Yeah, in that case, the judge may have been less tech savvy than even the opposing counsel. So what would be your tip for approaching that situation?
Yeah, in this case, it certainly wasn't very tech savvy. It was quite a long time ago too, in the early days of way pre-smartphones, back in the early days when computers were only just being adopted as personal ones. So a lot of people hadn't even used computers back then. I was involved in some of the early handhelds and PDAs and palm tops. This case came up where, in fact, somebody had been saving records on one of these early computers and been deleting them. And I said, well, do you know that maybe they're not really deleted? So I was able to undelete them and retrieve all this data. So trying to explain this as to how this could be done. In fact, it's very simple because of the mechanism that was often being used and still is of saving the data. When you want to delete it, you just flag it. we call them flags. And this is interesting analogy. It occurred to me, started talking about analogies, and it occurred to me how many analogies are used in high tech. So instead of having to delete all of that data, which is a bit time consuming and energy consuming, you just flag it as simple, one thing that says whether it's deleted or undeleted. So kind of all you have to do is to change the flag from undeleted to deleted, and hey presto, it's all there still if it's not been deleted. So using analogies like that, I found was very good in trying to explain these actually quite complicated software technology issues to laymen.
We're going to come back to analogies. That's a really good topic. Dan, as a trial consultant, how do you meet the challenge of assisting in expert testimony?
Of course, we work with all kinds of experts, from people who would rather have literally no imagery displayed at all, and they're uncomfortable with that, to those who have total clear idea about what visuals they want to show to support their testimony and how they are displayed. So either way, on either end of that spectrum, it's our job to collaborate on what the story is and tease that out, right? And then we can help best visualize it. A lot of the expert testimony, like Ian's, is scientific, right? And so a quick and credible lesson in a topic of interest in a case, whatever it is always going to be enhanced by graphics. It's truly necessary to teach, I think. And we can and we do make beautiful graphics, but that's not necessarily the primary goal. It really isn't, right? Graphics shouldn't be necessarily so eye-catching that they distract from the point of the argument being made. I mean, it's pretty simple. A judge, a jury or judge or a panel should come away, I feel like, grateful that the graphics help them understand the issues. And we do hear that in post-trial interviews, which are generally conducted by our jury consulting team in trials. So above all, we want the demonstratives to be compelling. And from a graphics perspective, teaching and clarity are key. And I think the experts would want that and would agree with that. But usually my first goal in these meetings with experts and clients is to grasp the concept so that I can help translate that to the jury, obviously. I mean, I'm a lay person who needs a minute probably to absorb the meaning of what you're telling me, especially if I've never heard or thought about this topic that we're discussing, which, I'm grateful to be in a job where it's interdisciplinary. I get to learn a lot of different things. So whether it's something very technical, like what we're talking about with Ian's work, or real life example, the propulsion system of a toy fish, spring propelled, right? So if you're the expert that's hired to explain that system because it's the issue in this patent dispute, it's my job to help you tell that story of the fish's propulsion system in the bathtub in a way that's engaging and informative and hopefully helps us win for you.
So what does that back and forth process look like? I mean, let's say that you and Ian are in a case together. So what does that look like to create that final piece? Well, it's iterative, obviously. I mean, a lot of experts, a huge portion that we work with are academics like Ian, right? And who have a lot of teaching experience. So explaining things in court or in arbitration is usually second nature to them. They're great to work with because they're used to storytelling and the use of visual aids usually. But sometimes they need to be reminded that they're speaking to regular people and not their grad students. But generally they're teachers and they're relishing the opportunity to connect with people, whether it's jurors or judges or panels. So we'll kind of work with that, I think, as a starting point. Why are we here? Why are you here? What's interesting about the case? How can your expertise help the jury understand why they should believe, our side? And so these are the kind of questions that get us going. And then it's just the back and forth, the sort of sausage making of the creation of graphics. It's just getting the work done. So I'd like to transition here, Ian. I'm going to come back to you here and kind of the anchoring point with your written report. What are your best strategies for a written report, and really, how do you approach that?
It's obviously a big part of what an expert witness has to do, and so much hangs around your expert report. So it's so important. Now, the thing is that there are some very different ways of going about it, and what I found is that there are big differences, certainly between the UK and Europe and the US. My early cases were over here in the UK, but most of my cases since then have been in the US with US law firms, attorneys, and trials and so forth. And even within, say, the US set of law firms, there are quite big differences as to how they like to go about it. I found in the UK, for instance, that it's much more common for the expert to be left on their own almost entirely and write the whole report themselves. Maybe given a thin template, but generally left alone to get on with things, with some talking to the counsel, going back and forth, understanding, explaining some issues to them and seeing where they want to go with it, but pretty much writing it yourself. I found it rather different in the US, with US counsel, in that they will certainly want more participation in it, at least as far as providing templates go, heavy templates, the way the report's laid out. And obviously you need your counsel, because I mean, I'm not a patent expert, a patent attorney myself, so I don't know, the law as it pertains sometimes. So you need help from your attorneys to actually put in that boilerplate some of the important legal issues that they might think need to be in there. But apart from that, they'll either, again, leave you on your own and you get on and you fill out the real meat of it, which is where, of course, your expertise comes in, because, you're hired as the person who really knows the deep stuff about the technology, if it's software or hardware or whatever. So that's the real sort of meat of doing the expert report. Now, sometimes they'll kind of like to be quite involved in that, and you might just end up talking to them a lot, with them taking the notes and then them actually writing it. So there's quite a big, it's interesting, there's quite a big variance in the way that these expert reports come about. But some of the key things I think about it is to, I've always felt that being an expert witness, that I'm impartial. I'm not there really to take sides. Yes, you're, taken on by one side of the argument in this law case, but you want to try and, keep it down the middle, straight, be impartial, just offer your best technical advice, explain the issues to them. Don't be biased. You've got your credibility to maintain too. So keep it like that, and then you'll get a good report out of it. So those are my basic strategies for it.
Dan, you work with the experts to bring some of the complicated processes or concepts out of the report and to create a visual. So how do you get involved, and maybe can you describe that process from the report itself?
We'll get the report completed from the expert, and to a consultant and a graphics person, I mean, it's gold, right? It's even more so than potentially the complaint. It's digging into specific, really important issues, and usually has figures or some kind of visuals, within the report. And sometimes part of our job is to actually take those figures and enhance them or make them, more jury friendly. How do they look on a slide? So sometimes it's as simple as taking detail off, to highlight what's important. So, expert reports are gold for a trial consultant. And in recent years, it's interesting. It's become more common for experts we work with to ask us to actually assist with their reports. And I find this in arbitration, briefs as well, even more so potentially. And it's partly a function of the fact that at IMS, we do expert placement, and so now we have a chance to get in way earlier in the process and meet with and speak with experts sooner than we would otherwise, and that we do on other cases. So that enables us to take part in some really preliminary visual strategy, which is great. And sometimes you will get to see that in the report, so we'll have input. I mean, of course, a lot of experts will have teams behind them that help them put together their reports and their figures and stuff, and so we'll work with them as well. But of course, we also get involved just through attorney connections and repeat clients and experts we've worked with on past cases who look to us for help. And of course, this is true when we're revisiting technology or patent issues that are recycled or that have been tried in the past for which we've created graphics. Just makes sense to bring us back. But so in other words, the expert doesn't have to remake something, reinvent the wheel if they have it already in some form. Okay, let's say the report's done, Ian, and now we move to deposition. I'd love to hear a little bit about your strategy for preparing for deposition.
Yeah, as I expect everybody in the audience knows, depositions are the grueling thing for this part of the whole process. And it's funny the number of times when I've been taken on for a new case and the attorneys will often in the early days say, well, do you like giving depositions? And of course, anybody who's really truthful probably doesn't really like giving them, but they're a necessary evil, as it were, and a very important part of the whole process. So even though you don't really enjoy them, you have to do them, and you do the best you can and make the most of them. And they can be grueling. They vary quite a lot. So my sort of strategies, it depends. I mean, if I'm in the US, well, even the US, of course, you have 4 time zones in your country. So there might be some travel involved, and you've got a bit of jet lag there, especially going west to east coast, I find. A bit worse for me if I'm in the UK and flying out to the States. It's 5-hour difference to the East Coast, 8 to the West Coast, California, where I often go and used to live and work. So jet lag is a big thing that you have to, take it into consideration to start off with. So I try and get out a day or 2 early, get over the jet lag a bit. Just spending plenty of time with counsel. Again, going over your report. You don't have to, you're not expected to memorize it. You have that expert report with you in the deposition, and you're allowed to refer to it. So that's very useful, of course, prop for you. But yeah, just working with your counsel, understanding what their strategies are, I always ask, well, what sort of points are the opposing side going to try and catch me out on, frankly, or what sort of points in my report are they going to focus in on? And are there some areas where we can focus ourselves to make sure we've got a really good story here for it. Apart from that, staying calm with it, being rested, not getting flustered, taking your time. One of the great things I've been taught by counsel is that, you really do have whatever time you want. And these are long days. I mean, nominally, it's about 7 or 7.5 hours of grilling time, as it were. But with breaks and lunch and everything, it can be quite easy in an 11-hour day. So it's a very long, tiring day. But one thing is you can control the timing of it. And if you're asked a question, time and again, you are taught to say, well, let me refer you to my report. And then you take a few minutes flicking through your report, finding the place that you're trying to point them to that, perhaps read it out, get them to read it out. So these sort of tactics, you can try and control it. So it's really trying to control the deposition as best you can and not have that control taken away from you by the opposing counsel. Also, they may well have worked with the opposing counsel before and will understand what sort of way they go about taking these depositions, and if they're what their sort of attitudes are to cross-examination. So that can be very useful in prepping yourself for what you're going to expect in a deposition.
You mentioned a little bit about meeting with your team and certainly wanting to know the strategies for how you're going to be crossed, but can you talk a little bit more about the initial prep with the team hiring you? What does that look like?
Yeah, sure, because they want to collaborate with you to get the best possible they can out of this whole team. We're typically working with 2 or 3, one lead counsel, a couple of other people helping out too. They'll have their own expertise in some areas, so you want to know that and understand how you can explain to them some of these issues. But again, I'd stress that as an expert witness, you're an independent advisor, really. So you're not, yes, you're retained by counsel, by that law firm, but you don't work for them strictly. So you need to be independent. If your counsel is bringing up points that you don't think are right, then you have to raise those issues with them and discuss it and see what sort of tack you can take in some of these trickier areas. Keep your credibility always as an expert witness, because that's what they're looking for as well. I think in these initial preps, that they're getting good, solid, straight advice from you, and assure them that you know what you're talking about, that explain the areas you've worked in, explain these sort of sometimes difficult concepts, and try and understand what they need to know in this whole process. But finally, I think the more that you can do, the more you get involved in, the better you get with them, and the more experience you can get under your belt, and the more you can help out your attorneys and your law firm.
So back to opposing counsel, in your 31 cases, I'm sure there's had to be some challenging moments during cross-examination. Do any come to mind?
Yeah, sure. There have been some difficult ones. I've had the table thumpers with the guy literally banging on the table. And I've had the guy go red in the face, accusing me of deliberately not answering questions and things like that. They're just trying to fluster you, for you to lose your guard. I had one where it was a video deposition a few years ago during the lockdown phases. And there were three attorneys, well, one attorney and two other guys, I didn't really know why they were there on the video. And one of them was just behaving obnoxiously. He was just like staring at me and laughing and trying to put me off. And in the end, I did make a break in proceedings and say, why is that guy there? And they did remove him, actually. So there are all sort of tactics that are used. Another one that gets sort of a bit, they're trying to embarrass you. One thing you're told is that in a deposition, it's your expert report. That's what you've written, that's what you stick to, that's what you refer to all the time, and that's what you point to them. So if they start asking you questions outside that, that's actually not allowed, really. They're supposed to be asking about your expert report. So I've had times where one of them will brandish a patent I've never seen before and thrust it at me and say, well, what do you make of this patent then? And of course, they're trying to trick you because they're trying to get you to make an opinion on that when you won't have had time to form a proper opinion. So I had one case, it was extreme, where he took out patent after patent after patent. There were literally about 30 in all. And each time I'd accept it and I'd say, well, I haven't had time to review this. I haven't formed an opinion on it. And then they come back and say, well, what do you mean you haven't formed an opinion? You're supposed to be an expert, aren't you? Why haven't you got an opinion on this? So you have to explain, well, no, I need time to digest it and go away and do my research and so forth. So those are the sort of things that get difficult in depositions. They do occur quite often, I must admit.
Your example about the contentious situation in a video deposition, we've seen cases where counsel will request that questioning attorney will, and whoever is going to be on the other side of that will also be on camera, and we'll have multiple cameras in the room in addition to the witness. So sometimes that can help to kind of neutralize that example, but yeah, we've definitely seen that too. So moving along the life cycle here of a patent case, Dan, it's been said that cases can be won or lost at a Markman hearing. What is the role of a trial consultant during a Markman hearing?
Right. In patent cases, usually oftentimes with technology patent cases, we'll get involved by the client reaching out to us to help them prepare their technology tutorial, which is a required component of a Markman hearing. So these are filings, these are technology-based filings that each side provides, sort of supposed to be kind of neutral. And it's each side telling the story of the patent technology at issue. And so we work with the teams to use animation usually and voiceover. It's literally like a movie, sometimes interactive, sometimes it just plays end to end. And this is intended to instruct the court in the basics of the technology. And we can develop these drafts usually just straight from the trial briefing, which is handy.
Mm-hmm. Do you have any other ways that you help attorneys in that preparation for the hearing?
Well, yeah, because that's, the tutorial generally is before the hearing, right? So in addition to storyboarding the tutorial or working with that, we also, for the presentations themselves, we have clear templates to display the claims and the language and the figures. I mean, that's what the hearing is all about, is about fighting over the words in the patent, right? So, and this is kind of off the shelf stuff. It's generally we can generate these slides for hearings without a ton of back and forth based on the briefing, and it's kind of plug and play.
We're going to move along here in the life cycle of this case. After you've completed the work for a Markman hearing and the case is going to continue, what sort of services do you offer moving forward? How do you stay involved?
Sure. I mean, it's really dependent on the client's needs. So obviously the Markman is often the first step that we get involved in. And again, starting with the tech tutorial, but then the hearing itself, after which there is some kind of ruling about where things stand. Then any pretrial motions, other fights along the way, sometimes their need of some visual help for these proceedings. And then, we very often get involved in mock trials of course, to help guide the strategy ahead of trial. So of course, ideally that mock is going to occur after most of these major issues have been decided by the court, to certainly make for the most accurate test in that mock.
We've learned a lot here today so far about, kind of how graphics can contribute to an understanding of complex issues. And Ian, thank you very much for sharing your experiences and insights from an expert witness point of view. Let's see, I know we've received a few questions from the audience, so let me take a look here. Dan, I think this first one's for you. Okay, it's a great one. What's the most complicated technology you've had to explain, whether it's an arbitration panel or jurors or even a bench trial?
Well, I'm not a scientist, so they're all pretty challenging and complicated from my perspective. I guess probably one that comes to mind, we had to teach the nuances of chemical structures in a biopharma case, right? And so this is where our client had an amazing cancer drug. And we had to show convincingly that the difference between this life-saving cancer drug and a deadly poison was a tiny nuance in the molecular structure of this drug. And we also had to dig deep into how it was discovered and the history of the research and development and all the resources that went into it, the successes and failures. Of course, that's all part of the case story. And that was complicated to unspool it. But talking about that structure, we ended up having to rely on and create a really sophisticated 3D representation of it and drive around it, to make the point. Otherwise, it was really difficult to explain. And I think we actually did it in 2D and 3D animation so that you really saw every possible angle that we could make that point, and it was successful. So
Ian, this has got to be like a drop shot at Wimbledon for you. You've got to have tons of examples of explaining something complicated.
Yeah, they've all been complicated, so plenty of examples. But I think probably the most complex, I've alluded to this a bit before, it won't be a surprise, is really the internet. How does the internet work? Very simple question. We're all so used to the internet. We're on the internet right now. But actually, how is this all hanging together? How can it be that we can see each other and listen to each other, talk to each other across the worlds, across these time zones and so forth? So again, it's kind of like I've been saying before, it depends on who you're trying to explain this to. One of my colleagues, I could explain, we could have a great discussion of very deep levels about how some of these technologies work, how these packets are kind of sent around and how you look up domain names and this sort of thing. But that could be entirely inappropriate for other sort of audiences. So I think as an expert, you need to come up with these different ways of explaining a particular subject like the internet, how the whole stack hangs together to different sort of target audiences, and come up with simple analogies. Don't try to confuse the areas if they don't need to be confused. If you do need to drill down into some of them, because that's the sort of target person you're talking to, then be prepared to do that and do get really down in the weeds, because that might be very helpful for them. On the other hand, it could just be too confusing for most people, and they don't need to know that level of detail. So I'd certainly say, yeah, try and explain the different facets and all the different parts of the internet. There's no one such thing. There are so many different components that need to work together to get it all to work. So certainly a tricky one I've found in the past.
Okay, here's another one. Dan, I think you can answer this one again. And I think this could be for expert witnesses or attorneys presenting. So what tips can you offer specifically to the visuals when you're explaining that complicated issue, graphically? What sort of tips can you offer?
Well, of course, it would depend on the issue. And like Ian's talking about, we're often put under pressure to think up analogies to explain stuff on the spot. So we're kind of trained to have to do that for the more difficult to understand stuff. And sometimes analogies aren't really necessary. I mean, sometimes with technology patents, Well, usually we'll start with the figures, right? And think about how best to bring them to life or bring them into the real world, right? I mean, taking basically stick figures and either translating them to something real or making an analogy for it. A train cars coupling and decoupling, capacitors on a circuit, sort of simple, random, stuff like that. So, obviously an analogy is a storytelling tool. Let's go back to the story. I mean, there's so many sort of go-to analogies we all recognize that make points instantly. We already have them in part of our shared language. I'm thinking of Jenga, right? Or a house of cards collapsing when a crucial piece is removed. These are obviously things that the jury or judge or whomever is going to pick up on instantly. We have hurdles on a track, bridges with missing planks, pathways. And these are analogies that obviously are common and they make for easy and good visuals. And of course, the key is to consider any pitfalls of these. Are we oversimplifying things? Is it the right tenor for the audience? I mean, a jury of younger people may hear an analogy totally differently than a jury of, I don't know, my peers that remember the world before the internet. So you want to consider the audience and whether this analogy is universal and could backfire, be used against you, etc.
Well, I've got to ask, I always love this topic about analogies. I was listening to something on talk radio and they actually use that Jenga analogy. And in my mind, I can perfectly picture that. And it makes sense when you connect it that way to the spoken language. But do you have any more maybe specific ones in, say, an IP case?
Yeah, and funny about Jenga, like we actually in the past have done a 3D model of Jenga and, like it's Pixar or something. And it's like,
Yeah.
We should probably just videotaped it. But we had a very technical IP case involving more Ian's realm. About how packet data is sent and received and things like that. And we had to come up I think it was for closing, like a very sort of quick, graspable analogy for the consequences, if all this starts breaking down and simply ceasing to function. The challenge was to make it, the point, with no slides, and just immediate impact, no words rather, and just immediate impact. And so we came up with an acrobat suspended in midair, having, left the trapeze, but without another one to catch, and seemed to be a winner. So that's my example.
Well, I have to ask if you, this is actually not one of the questions, but it come to my mind. Have you ever seen one of these backfire? I know that some attorneys are a little reticent to use analogies for a number of reasons, but have you seen any backfire?
Right, and personal prejudice might get in the way, and we don't know why someone likes something and it doesn't, resonate with somebody else. I actually haven't seen that happen very often, but that's also why analogies get tested in mock juries, right, or graphics in general, right? I mean, since an analogy as a rule is subject to interpretation, you have to be careful about how a jury or a tribunal or a judge in a bench trial is going to receive it, and just be aware of how it might get thrown back at you by opposing counsel.
Okay, there's another one here. Ian, this is going to be for you. Are there different sets of strategies for expert reports in the UK versus the United States?
Yeah, and as I've been saying earlier, that there are different ways that the law firms and attorneys will work with you between the UK and Europe and the US, and within the US themselves, that they can have different ways of working. But also, of course, the style of patents and the types of patents. My personal sort of preference and experience, I've got several patents to my name, I would typically file in the US first, and that's for strategic reasons, because you get a priority date 12 months beforehand and so forth, and you can tag your UK or European or Japanese patents onto that too. But you tend to tailor the patents, and this is the difference between the UK and US, to the particular product, for instance, that you're trying to protect. And these different countries, whether it's UK or Europe or US or Japan, Far East, have different sort of sets of technologies and products that they want to protect. So there's a different strategies come up with this. I mean, for instance, the US, especially Silicon Valley, is very tech heavy. You've got wonderful companies, like Facebook and Twitter and Google that come out of this. And their patents, Apple, I've worked with a lot, and Hewlett Packard and so forth. And they're very strong in these sort of technologies, whether it's hardware or software, computing, operating systems, communications, Qualcomm. So there are particular sorts of patents, and there are particular strategies for wording them and getting them through, and then supporting them. Whereas in the other parts of the world, there are different strengths and weaknesses in technology or other sorts of areas. So again, you find quite different sorts of patents. You have to get used to them being laid out rather differently. In the States, you're very used to US patents, and there's a particular style which I like a lot of the way that you standard formatting for them. Well, actually, other ones, UK, European, are formatted in different ways too. So you have to get used to the way that these are set out, and the way that you work around them, and where to find things. Again, those who know of US patents know that all the important part of the claims are put right at the end. Well, in other countries, the claims aren't right at the end. So, you have to look around a bit and find parts of the patents that you need to refer to. So that's why there are these differences that you need to get used to if you're sort of a global expert witness writing expert reports.
Oh, I knew this one would come too. Okay, let's start, Ian. Within the umbrella, it's about intellectual or artificial intelligence, I should say. Within the umbrella of IP, what kind of potential litigation issues do you anticipate because of artificial intelligence?
Yeah, and that's certainly a hot current topic at the moment, with all that's been going on recently, explosive in the last sort of few months or year or so with AI, ChatGPT and so forth. Of course, everybody knows that name now. As an aside, the funny thing with AI, which I've been very involved in over the decades, frankly, is that it seems to me in my working life for the last many decades, it's you go back to the 50s and 60s, and that was it. AI became really big for a short time, going to be the next big thing, and then it dies away. And it seemed like every 10 years or so, AI would come back. And I myself, I've written AI software a lot, which was very interesting, very useful. This was 30 years ago or so. Looked like the next big thing, went away again. Well, here we are again. It's come around for the 5th or 6th time or something. Looks like maybe it's here to stay. There's so much resource, so much money, so much manpower being put at this. Will it go away again? I don't know, but it's on everybody's lips, of course, at the moment. As to where is this going with litigation over IP? I think the two big obvious ones which are worries are of software source code, for instance, and images. And we've seen lots of examples in the popular press with this. As far as software goes, I mean, I myself, do use and have tried out the engines for writing bits of software. I must admit I'm skeptical as to how good they are. I would say there's only one case where the code was actually any good. I've had code produced that was frankly rubbish, just wouldn't compile. Other times wasn't really doing what I was asking it to do. But where did this code come from? I mean, we need more openness with this. Has it been stolen? Is it all open source? Who might claim, the intellectual property ownership of this? So I can see increasingly there being issues about this code coming from somewhere and there not being the traceability for it. Another big area, like I was saying, is in images, graphics, photographs. We've seen again in the popular press, I think, examples of some photographer whose work on animals, for instance, there's a famous one, which was a lion, I think a lion or tiger perhaps, had been blatantly copied, slightly different. I thought it was pretty obvious which one was, human generated, perhaps it was a painting, human generated, which one was artificially generated. But there's the thing of ownership. I also got an engine to write a song for me, some lyrics for a song in the style of a particular band of mine, favorite band. So, it's going to be a hotbed, I think, of some litigation in the years to come until some real guidelines are sorted out for it.
Well, my only question is, was it the Beatles? Was it the Beatles or was it U2? Which one? Either one?
It was an obscure punk band from over here that was my favorite, called the Stranglers, as it happens. So in the style of the Stranglers.
Actually, I was thinking as you said images. Dan, while we're on this subject, how would you feel if you saw one of your graphics you've personally designed used by AI?
Oh, man. Well, I'd probably experience a range of emotions, right? From anger initially to flattery. And then maybe, depending on how close I am to retirement, acceptance.
Ian, you kind of touched on it. I mean, do you see AI, the benefit as a tool within kind of the realm of expert testimony and patent litigation to further help you do what you do, distill complex technology down?
I think there's potential there for that. I'm cautious about it at the moment. Certainly using AI in cases, it's a bit like quoting Wikipedia in your expert report. It's not it's not yet robust enough for that sort of thing. AI, I experiment with it. I'd be cautious about including anything from it in an expert report, certainly without talking to my counsel a lot about this. Again, we're touching on legal implications of including some of these things generated by AI. I think that as time goes on and it's refined and the boundaries are understood, it's going to become a more and more useful tool for working on your expert report. But again, I would just urge caution at the moment in these early days that we don't understand the implications well enough yet. And I certainly would not and can't imagine really for a long time, if ever, just saying, write me this expert report and it in the way that some students are getting their essays pre-written like this. That's not the way to learn, and that's not the way yet to produce an expert report. Maybe one day they might do as good a job as me, but I think that's still a fair way out, and maybe never, I hope.
Well, thank you both. It was a great discussion. Ian, I'm going to need a link to this punk band. I want to check that out.
Wrangler's great.
Yeah, thank you all. Thank you to Ian and Dan for speaking with us today, and a special thanks to our listeners. Please join us next time and subscribe to the IMS Insights podcast. IMS has delivered strategic litigation consulting and expert witness services to leading global law firms and Fortune 500 companies for more than 30 years in more than 43,000 cases. IMS consultants become an extension of your legal team from pre-suit investigation services to discovery and then on to arbitration and trial. Learn more at expertservices.com.